respected audience. Today I propose to discuss will or wasiyat under Muslim law. Ladies and gentlemen, whosoever is owner of a certain property or properties, being the owner of the property, he has a bundle of rights with regard to the property he owns. One of such important right is unrestricted right of disposition. Meaning thereby, or it means that one who is owner of a property or certain properties, being the owner thereof, he has got the power to dispose of it to anyone in the name of any person by any legally recognized means such as sale, gift, and will. So these are the most popular legally recognized means whereby an owner of the property may dispose of or may transfer the property in favor of a person of his or her choice. And law does not put any restriction on the uh, on the on the power of transfer of the owner. Means anyone and any person who is the bona fide owner of some property, one of the attribute of his ownership is that at any point of the time he can transfer the ownership of the property, or he can transfer the property in the exercise of the power given to him or her, and he can make the transfer of the property in the name of any person of his or her choice, provided the transfer is within the regulatory mechanism of the law governing the subject. Therefore, the will is a legally recognized means by which the owner transfer his property or her property to anyone which he desires to take effect after his death. The transfer of property by will basically is called as testamentary disposition. It is also known by another name, that is bequest. It is also called as wasiyat or will. Thus, will is a device or an instrument with the help of which owner of the property makes a disposition that is to take effect after the death, after his death, and which by its very nature is revocable. Friends, since wasiyat or subject matter of the wasiyat is a legal subject, it is a legal proposition, wasiyat is a legal proposition, therefore it has been defined by the authorities on Muslim law. The important definitions given by the authorities on Muslim law are: number one, definition of the wasiyat as given or framed by the author of a book that is known as Durrul Mukhtar. So basically, Durrul Mukhtar is a book of fiqh, or it is a book of Islamic jurisprudence, wherein various legal proposition has been explained, defined. Therefore, according to the author of Durrul Mukhtar, what is the will? I quote, will is an assignment of the property to take effect after one's death. Meaning thereby that will is the property which is assigned or given to another person, but the property or ownership given to another person in respect of a particular property will come into effect only after the death of the transferor. And therefore, author of the Durrul Mukhtar says that will is an assignment of the property that to take the effect after one's death. There is another authority on the subject of Muslim law, that is a book of Hidayah. Hidayah basically is a treatise or compendium on the subject of the Islamic jurisprudence, and the author of the Hidayah chapter wise has discussed the rules and principle or the legal proposition relating to various subject matter. Maybe subject matter may be purely of spiritual nature, or it may be purely of temporal nature. Since the author of the Hidayah has done the work, legal work, on both the subjects, that is, on the subject which are directly related to the spirituality, spiritual matters. At the same time, there are various subjects which may not be directly related to the spirituality, but may be important, or maybe the human dealing may be important even from the temporal point of view, uh, from other point of view. Since wasiyat involves the transfer of property by one person to another, therefore, though it is making of the wasiyah is the divine order or direction, but it is normally considered as temporal matter. Even then, the author of the Hidayah has focused to define what is the wasiyat according to him from the practical point of view. According to this authority, wasiyat means an endowment with the property of anything after the death, as if one person should say to another, gives this article to mine after my death to a particular person. Then friends, there is another important and very practical definition of the proposition wasiyat. Wasiyat has been defined by the Tayyabji in his own words. And what a practical definition was given by Tayyabji. According to him, what is a wasiyat? He says, I quote, wasiyat is a legal declaration of the intention of a Muslim with respect to his or her property which he or she desires to be carried into effect after his or her death. A very simple but technical uh, language has been used by the author Tayyibji while defining the word wasiyat, and therefore he says that wasiyat is, according to him, wasiyat is legal declaration of the intention of a Muslim with respect to his, of course, her property, which he may desire to be carried into effect after his death. Since wasiyat is an integral part of the legal matter, and it is wasiyat is recognized as a mode of transfer of ownership in respect of some existing property by one person to another, which is to take effect after the death of the transferor, not only under the Muslim law but even under other legal system. Wasiyat has been recognized as one of the mode of the devolution of his or her property, which he or she desires to be carried into effect after one's death. Having regard to the juristic definition as well as uh, the definition of wasiyat as given under section 2 subclass H of the Indian Succession Act 1925, because there are two set of the definitions, or one set of the definition has been formulated by the jurist on Muslim law, celebrated jurist on Muslim law, like author of Hidayah, Durrul Mukhtar, Tayyibji, etc. At the same time, since it is a subject matter of the general interest, therefore across the religion, the meaning or definition of the term wasiyat was required. Therefore, in India, during the British period, in 1925, an independent separate act was passed, and that is known as the Indian Succession Act 1925. And now, in India, various aspects of Muslim law succession, they are directly governed by the Indian Succession Act 1925. Now, therefore, the point is that what is the will according to the Indian Succession Act 1925, which of course is obsolete in the modern uh, uh, legal education, but it has been defined in a way as to what is the definition of the this wasiyat according to section 2 subclass H of the Indian Succession Act 1920. Section 2 subsection H reads, I quote, will means legal declaration of the intention of a testator with respect to his or her property which he desires to be carried into effect after his death. So one will not find much difference between the Tayyibji and section 2 subsection H of the Indian Succession 1925, while reflecting upon or considering the subject of the wasiyat or topic of the wasiyat. Therefore, we can conclude here by saying that will in fact is formal expression of the intention of a deceased of a Muslim who has died, which he desires to be carried into effect after his death. This is the conceptual discussion on the topic of wasiyat what is the wasiyat and what are included within the meaning of the wasiyat. Ladies and gentlemen, here I proceed to examine the distinguishing feature of a will from other disposition of the property by its owner. The distinguishing feature of a will are: number one, it is taking effect after the death of the testator. It is its revocability is possible only within the limit of revocability is possible means one who has made the will, he can either continue the will, or he at any point of the time he realizes of his mistake, he can take a decision to revoke the will. That distinguishing feature of a will from other disposition of the property by its owner are that it takes effect only after the death of the testator. Means that will is made by a owner in respect of his property in his lifetime, and will is to be operated only on the death of the testator. So, this is the cooling period. Anyone who is the owner of certain property or properties, being the owner, I have already said that one of the attributes of the ownership is that it makes the testator entitled to dispose of the property either by sale or by gift or by work, etc., etc. There is no restriction, there is no limitation operating on the testament, on the power of the, and therefore one being the owner of the property is also equally important to dispose of his any part of the property or entire property, that too in the name of any person of his choice, provided the choice is not within the category of the testamentary rule. In that very situation, on the death of the owner, property can evolve or can take effect after the death of the testator. The second feature is that it is its revocability, meaning thereby that at any point of the time in the life, if otherwise the owner is not unfit, the ownership can be transferred to somebody else. However, the transfer will be according to the rule of Muslim law, not according to the whims and fancy of the authorities or writers of the Muslim law. So basically, the basic or the distinguishing feature of the wasiyat are twofold. Number one, that wasiyat always take effect only after the death of the testator, means only after, and it is revocable, means the wasiyat is not only the, but it becomes the revocable only after the death of the testator. Therefore, unlike any other disposition such as sale or gift, a will takes effect from the date of the death of the testator. Till he is alive, he is the owner of the property and empowered to exercise his full control over it. The legatee or beneficiary under the will cannot interfere in any manner whatsoever in his power of enjoyment of the property, including the disposal. Therefore, executing a will does not adversely affect the power of the owner. What happens that the owner of the after power in favor of any person, including the legatee, either inter vivas or even though any other testamentary is. A will, therefore, a will by its very nature is revocable. It can be revoked by formal cancellation or declaration, or can he be automatically, can it be automatically revoked by the testator or executing other will. The executing, therefore, friends, it can also be rendered meaningless if the testator, after executing the will, transfers the property or nothing is left, then that be the subject matter of the will due to an involuntary disposition, such an execution of money, decree, or payment of the matter, the testator will be executed. A will be executed by a person who will also be revoked if the loss his insanity and becomes the unsound mind subsequent to its execution. Ladies and gentlemen, now I am going to discuss another aspect of the subject of the will, that is, what is the object of a will under Muslim law. I have already discussed that law relating to the will or testamentary disposition for Muslim is divine in nature. That is, it is regulated by the Holy Quran and is supplemented by the traditions of the Holy Prophet. There is primarily of making a will to the extent of only one third of the net property. Therefore, the first and foremost object of a will under Muslim law is that it prevents a person from interfering and defecting the claims of his full owners. So, the restriction ensures that at least two-thirds of the property must be succeeded. So, the restriction ensures that at least two-thirds of the property must go to the succession. It is applicable only in those cases where the testator enjoys his property during his lifetime and does not dispose of his asset in interval. Secondly, the second object of wasiyat under Muslim law is that secondly, by permitting a testator to bequeath one third of his property, he is empowered to set his just claim of the property. His pleasure, who might not figure in the heirs category, these person might be relatives other than heirs or even a stranger to the family. The while to the extent of one third can be made for charitable purpose, for religious purpose, parents may be participate. However, if there is a custom to the contrary which limits the object of the power, if there is claim or counter claim, however, if there is a custom to the contrary which limits the choice of the testator in choosing a beneficiary with respect to his one third property, such customary practice would be upheld by law. It is necessary that something must have been done or is required to be shown as contribution by the beneficiary for the testator. The testator can make a will in favor of even a stranger, although usually the property is bequeathed for returning of the favor of another person, such as services rendered by the parent or a servant to help finally relative by marriage. If he is inclined to do so, he can make a bequest for general public welfare, for a specific purpose, or even for a religious institution. Now, I am coming to another important point, that is formalities for making a will. Friends, will basically is a kind of transaction, that is a mutual kind of the transaction between the two persons who are familiar with each other, or sometime maybe the stranger with for each other. But as I have already pointed that making of the will by one person in the name of another person basically amounts to help the other person. That is the legatee. There, since it is a general welfare scheme specified under Muslim personal law, therefore, there are not specific formalities for making a will. There is neither any format that is laid down, or nor is there any requirement that it should be in writing. A will under Muslim law is as simple as anything. It can be oral. If it is not in writing, it should be in writing. It need not be signed. It does not require the attestation, and if it is environment, or in the form of the letter that in clear cut terms provide for the distribution of the property after his death would constitute a valid will. So, it must be kept in the mind that of course, the will under the Muslim law, scheme of the Muslim law is one of the important topic included in the Muslim law, and it is very important. It is very important for in the life of a person, and therefore one must be fully aware as to what is the will or what is the wasiyat, who can make the wasiyat, who cannot make the wasiyat. So all these things must be clear. So what are the formalities for making a will? There are no specific formality for making a will. Muslim law does not prescribe any standard formula for making the will. There is nothing, there is neither any format that is laid down, nor is there any requirement that it should be in writing. A will under Muslim law can even be oral. If it is in writing, it need not to be signed. If does not require attestation, the wasiyat, and if it is attested, there is no need to get it registered. Instructions of the testator when written on a plain paper are in the format of the letter, that is clear cut terms of providing for distribution of his property after the death. A will executed under Muslim law does not require probate. Where the will is reduced into writing, it is called as wasiyatnama, although no formalities are required to be completed. All with a willing with a will in order to be valid and effective must display the bona fide intention on the part of the testator to bequeath the property. So far as the formalities are concerned, I have already pointed out that Muslim law does not prescribe any SOP for making or executing a will, nor does it prescribe any definite format for making or executing a will. A will may be oral or it may be in writing. Both are allowed under Muslim law, because it is a dealing between the two persons, between the two persons. One is the owner and other can be a beneficiary under the transaction. Since it is a transaction whereby one person makes the transfer of his asset or makes the transfer of his property or ownership in respect of some property to another person, since it is a choice of the person to make the to transfer the property in the name of any other person, therefore Muslim law has tried to make this transaction as simple as possible. And simplicity is shown to this extent that though in the will or by means of the will, a bundle of the rights in respect of the property, that is ownership, is transferred. Ownership is being transferred by one person to another person. Even then, it is allowed that one can transfer his property in as simple way as it could be in the given circumstance. Therefore, one who is willing to transfer his property by means of the bequest or by means of by means of testament, he can make a testament, he can make a bequest either in words or it may be in writing. It may be oral or it may be the oral words could have been reduced into the writing. Both are allowed. Both are permitted. One, if I am the owner of my house and I want to transfer this house by means of the bequest to a person of my choice, Muslim law provides that I can make the wasiyat of my property, of my house, in as simple way as it may be. Means that just I can spoke the words, and by speaking the words, I can convey my idea, my intention, my wishes or my will, because what happens in the will, in case of the will, one expresses his wishes or desires as to what he wants with regard to his property in future, how his property should be handled or should be dealt with. It is expressed by the owner. However, the expression of the willingness of the owner with regard to his property, with regard to the future plan of his property, may be in words, spoken words, or may be in writing. Law further clarifies that where the wishes of the owner have been reduced into the writing, it is not necessary that it must be attested, because where there is a transfer of the property by one person to another person, under all the legal system, requirement is that transfer should be attested by the two witnesses. Means there must be two witnesses at least to certify that somebody has made the transfer of his some asset. Therefore, it may be oral, or it may be in writing, or it may be attested by the witness, or might not have been attested by the witness. Not only that, when there is a transfer of the ownership, means there is a transfer of the bundle of the right, and therefore it must be ensured that there is effective transfer of the bundle of the right in respect of a property. And in order to ensure that there is effective transfer of the property, it is necessary that transfer should be written on a piece of the paper, and not only written on the piece of the paper, but it must be duly executed under the Indian Registration Act. Once a transfer is registered, that will be the conclusive proof of the fact that Mr. X has made bona fide transfer of his particular property in a particular way to a particular person or set of the persons. But under Muslim law, this requirement has also been dispensed with. Muslim law says that one who is the owner of the property, he can make the transfer of his property by means of the bequest, and bequest may be made either oral or it may be in writing. Even if it is in writing, no need to be attested. Even if it has been attested by two witnesses, well and good, but it is not necessary that it must be duly registered under the Indian Registration Act, which is necessary for all kind of the transfer of the property under other legal system. But Muslim law does not require such type of the thing. What is required? That only there must be formal expression of the desire on the part of the owner in such a way that it is explicit to the rest of the people that property in question has been given to somebody else, and somebody else will be entitled to enjoy the property only after the date of the giver, that is after after the death of the owner of the property. So this is required. Only this much is, to this extent is required under Muslim law. The piece of the paper on which the wasiyat is drawn, basically that is known as wasiyatnama. Although no formalities are required to comply with, a will in order to be valid and effective must deal with the bona fide intention on the part of the testator to bequeath his property. Already I have explained that it is a formal declaration. If you go by the definition of wasiyat formulated by Taijabji, or section 2 subclass H of the Indian Success Act 1925, you will find that they have defined the wasiyat as legal declaration of the intention. Legal declaration of the intention of a Muslim with regard to his property which he desires to be carried into effect after his death. So it is legal declaration of intention. It is the formal expression of the wish or desire of a particular person with regard to how his property and to whom his property should go after his death. How much his property should be given to a particular person pursuant to his desire or wish. This is basically the gist of the will as perceived by the Muslim law. Therefore, Muslim law did not prescribe any format or any formality necessary for the making of a will by one who is a Muslim under his personal law. Ladies and gentlemen, how, of course, Muslim law does not prescribe any formality or format for making the will. But in order to bring about a valid will under Muslim law and to make it valid and capable of taking effect into law, it is necessary that formal declaration must fulfill certain conditions to be called as wasiyat or testament or will under Muslim law. And they are: number one, the testator should be competent to make the will with respect to his property. This is the first and foremost requirement for making a valid will under Muslim. The other is that the subject legatee must be competent to take the bequest. That is, the beneficiary should be competent to take the bequest. Third is, subject matter of the will should be valid. And fourth is that the bequest should be within the permissible limit of Muslim law. Ladies and gentlemen, who is testator and who is competent to make the will? What are the qualifications prescribed by Muslim law for a owner or person to be competent to make the will? Who is legatee, means who can be the beneficiary under a will or testament? The third is that what can be the subject matter of the will, means what can be given by means of the testament by one person to another. The fourth is that the bequest should be, wasiyat made by a person should be within the permissible limits, means it must be within the limit as set by Muslim law. So these are the essential attributes of a valid gift under Muslim law, and all these attributes of Muslim will under Muslim law will be discussed by me in my next lecture, that is on tomorrow. Thank you very much for today discussion. So next time I will discuss with the learners in detail essentials of a valid will under Muslim law. Just I have pointed out the points, but detailed discussion on these points will be made tomorrow. Thank you very much.